afternoon, everyone. I'd like to welcome you to today's webinar, Navigating the FLSA's Upcoming Salary Threshold Increases. Thank goodness Grant is here because I have no idea what any of that means. My name is Max Smith. I'm with 501c Services. We're hosting Grant today. As many of you know, 501 provides full-service unemployment management programs and other services to more than 3,000 nonprofits. Some of our most popular programs include the 501c Agencies Trust, which offers unemployment risk management assistance. And then we have another program, 501c HR Services, which is a confidential HR consultation solution to walk nonprofits through difficult personnel matters. A lot of you all on the webinar today are already using one of those two programs, and we appreciate you all for doing that and for being here with us today. Now, before I introduce Grant, I'm going to get some of our typical housekeeping out of the way, see if I can answer some of your all's questions before you text them over to us. First of all, will you get a copy of the slide deck? We don't know yet. Grant hasn't been given permission yet, but we're going to check on that later today. And if Littler will let you have a copy of the slides, we will shoot you a copy of the slides by email later this week. If you're here for HRCI or SHRM credit, you typically know how we do that. There's a post-event survey you need to complete. Give us about 48 hours, and we will shoot you the appropriate certification credits. Also, Grant's going to try to take questions throughout today, and then he will also leave time at the conclusion of his webinar to answer any questions. I'm going to sit in the background and kind of read those off to him. So if you have a question when some kind of topic comes up, go ahead and shoot it in there. We will tackle them as best possible. And then, like I said, we'll save some time at the end for anything that might be left over. So now I can go ahead and introduce Grant Goerke, an attorney with Littler Mendelson. Grant is in Minneapolis right now, so his main focus is on Minnesota employment issues. But he is a member of Littler's National Wage and Hour Practice Group. So that's why today he's going to be our subject matter expert on these FLSA changes and what all you all nonprofit employers need to know. Good morning, Grant. You ready to go?
Yes, I am. Thanks, Mac. I appreciate it. So we've got a lot of information to cover. I'm going to just go ahead and dive right in. As Mac mentioned, I'm a member of our firm's Wage and Hour Practice Group, and we've been helping all sorts of employers with questions about the new DOL rules regarding salary limits for exemptions under the FLSA. So I'm honored to be with you all today and help with you all with those same issues, especially for a group of nonprofits. I'm going to go over some general information about the exemptions that are at issue under the FLSA and particularly the ones that are affected by these salary increase changes. We'll go over those new rules so you've got an understanding of what's coming up, when those are going into effect, how those are going to change things. And then I understand there's been a good amount of people through your organization. I've seen this in my own work as well, of nonprofits questioning, looking at these increasing dollar amounts and saying, hey, do we even need to worry about this in the first place? We're a nonprofit. I don't think the FLSA applies to us. So we're going to go through that analysis, help give you some information about what factors to look at, how that determination is made. And then at the end, I'll go through some recommendations for folks that do think they're covered, that they're subject to these changes, how we go about doing that analysis and figuring out what updates, if any, to our payrolls, our employee identification, classification issues need to be made. And like Max said, feel free to ask questions as we go today. I'm more than happy to answer those. And I gave Matt the green light to interrupt me whenever questions come in. So I'm happy to do those. Otherwise, we should have about 5 or 10 minutes at the end as well. So I mentioned there's, the FLSA is the federal law. It's been on the books since 1938 that provides the federal minimum standards for wage, the minimum wage, overtime requirements, record keeping requirements for employers related to pay and hours worked, and then also child labor provisions. Our presentation today is focused on the exemptions. There's several exemptions to the minimum wage and overtime requirements under federal law. Those come from various sources, but we're focusing on the FLSA, EAP, or sometimes they're called the white collar exemptions. EAP stands for Executive, Administrative, and Professional. These are exemptions that were written into the FLSA by Congress back when it was passed in 1938. So they've been on the books for a very long time. What Congress did with the FLSA is to describe the duties that employees perform that will qualify for the executive, administrative, or professional exemption, and then deferred to the Department of Labor to implement additional regulations to further describe those duties and set out any other additional requirements that might need to be met in order to satisfy those exemptions. And like I said, there's a lot of other exemptions under federal law, and some states have their own exemptions as well. The changes that have gone into effect that we just heard about in April of this year and that are going to be changing early next month and then at the beginning of next year, those are only directed to these three specific categories of exemptions. So if you've got folks that are potentially exempt under other provisions or under other laws, you don't have to worry about the changes. But that said, these are the three most common exemptions. Particularly the administrative exemption is increasingly common for employers. And so this change that we're talking about today will affect that as well. So once Congress had passed the FLSA in 1938, DOL went about setting out regulations to help determine what these exemptions are, further define them, and help employers be able to decide which of our employees need to be paid an hourly rate and get overtime, and which can we have more discretion and potentially pay someone a salary and not have to worry about overtime. So for each of the EAP exemptions and those white collar exemptions, there is a three-part test for all of them: duties, salary basis, and salary level. I think a lot of times what folks think about when they're considering exemptions, they talk about the duties test. And that's a huge part of it. For an executive exemption, for example, the employee has to be supervising at least 2 employees. So that's a minimum duty requirement for that exemption to apply. But that's not the only part of the exemption as well. The employee, in order to be exempt, must meet those duties requirements, must be paid on a salary basis, and must be paid a minimum salary that either meets or exceeds the threshold set by the federal government. And so the changes that we've seen be announced in April of this year and that we're going to be talking about today only affect the salary level. So they're increasing that threshold, the amount of salary that employees must be paid in order to be exempt. And a big important piece of that is that it's not changing the duties test and it's not changing the salary basis test either. So it kind of helps us narrow the scope of what we need to review and how many things that we're dealing with here, because we can focus in on that salary level test. And I'm going to go over a little bit of the history. I'll probably cover this faster than some of the other information because it's not always the most practical, but I think it really helps understand why these tests are out there, what the purpose of the DOL regulations are, and then what kind of challenges we can expect to see once these rules go into effect later this year. So going back again, this is a law that's been on the books for about 85 years. Within the first few decades after that, the DOL passed the regulations that included the initial salary level test. And the way they approached it is there's just too many employees for the Department of Labor to consider everyone and start to examine, are these people actually exempt or not? So in order to kind of decrease their workload, more efficiently apply their limited resources, they said, let's just set a bar, and that anyone that's paid a salary above that, we're going to assume that they're obviously not exempt and they're not necessarily the focus of our investigations and what we're going to be emphasizing in our regulations and the work that we do. So the salary level test is a way to kind of weed out more people. Essentially, the analysis is if you're getting paid a salary that's above this threshold, there's a pretty good chance that you actually are exempt If you're meeting the duties test as well, that's what, the exemption is required. So it's just a benchmark to enable to kind of focus the resources and the applications of the federal FLSA and the DOL resources. So the salary level has increased several times over the years. When the law was initially passed, it was about every 2 or 3 years we were seeing increases, and that continued from the 1940s to the 1970s. In 1975, we reached a bit of a plateau that stayed there for approximately 30 years, and we saw no increases to the salary level tests. And then in 2004, the DOL finally, for the first time, said, let's readdress this situation. Let's bring the numbers into compliance with, more modern economics and what we're seeing for wage thresholds for folks. So in 2004, we got the first modern era change of the salary level increase. And that brought the level up to $455 per week, or about $23,000 per year for salary. So that was what in 2004, the DOL was saying, that's enough of a bar that if you meet the duties test and you're paid a salary at that amount, we're going to assume that you actually are exempt and you don't need to be paid overtime. And that test stayed in place for a while. And we'll talk about some of the extra efforts. But the way the DOL went about determining that amount is really important because it affects the challenges that we've seen in the past for other increases. And it's leading the way as to how we're going to see these 2024 increases challenged as well. But to summarize, a lot of rulemaking, legislative history real quick. The DOL looked at wage data for weekly earnings from salaried workers across the country, but really focused on the lowest wage region, which happened to be the South, and then the retail industry nationally. Those were areas that DOL determined were of particularly high need and focus for the department. So they looked at that data and set the threshold at the 20th percentile for weekly earnings for those folks. And that's where that $455 per week number came from. And that was ultimately implemented and went into effect and was on the books for several years. The first time after that the DOL decided to reconsider the salary limit threshold was in 2016. DOL again thought that it was appropriate to increase the amount to be more in line with the modern economy and what employees were seeing, costs of living, all those things, and proposed increasing the salary level to $913 per week. So almost double what the Department of Labor had done 12 years earlier in 2004. Part of the reason why that jump was bigger is because the DOL decided to set the bar, instead of at the 20th percentile, went up to the 40th percentile. And so we saw, even though, that's about 8 years ago now, it was a significant jump for employers, and there was a lot of pushback on this change. And so the law was scheduled to go into effect on, I believe, December 1st of 2016. And right around Thanksgiving time, when there was about a week left before the effective date came, a court in Texas said, nope, we can't go forward with this. Let's put it on hold temporarily. And then after further consideration, ended up putting a permanent injunction in, preventing the rule from ever going into place unless there was a change. The appellate court agreed, sent the rule back to the Department of Labor and said, you need to consider this further. And ultimately the rule ended up being, the rule change from 2016 ended up being dismissed and never went into effect. So we haven't had a salary increase to $913 per week. And the reasons why that change wasn't successful, why those efforts weren't successful in 2016, is interesting. And it kind of foreshadows what we're already seeing now, just shortly before the 2024 changes are scheduled to go into effect. Basically, the court looked at this and said, there's questions about whether the Department of Labor can set these levels, these salary levels for exemptions anyway. But Congress really was focused on the duties when it enacted the FLSA in 1938. And by creating a salary threshold that's so high, almost double what it was in 2004, it seemed like the Department of Labor was overriding the intent of Congress and making the exemption much more dependent on the individual employee's salaries rather than the duties they were performing. And so the court looked at that and said, that is the wrong way to approach this. Congress didn't intend for salary to be the primary determination as to whether someone's exempt or not. So this needs to go back to the rulemaking process and basically start over. That didn't fully deter the Department of Labor. Obviously, we've seen activity from them in 2024, but they revisited the issue again just 3 years later in 2016 and came back with a more modest proposal. And this time, and these rules actually did go into effect. This is what the current, as we sit here on June 20th, 2024, what the current salary test requirements are. Those were implemented in 2019. They went into effect without a successful legal challenge. So we've had them on the books for about 5 years now. But what that rule said is if you want to treat an employee as exempt under the EEAP exemptions, those executive, administrative, or professional exemptions, the employees now have to be paid a salary of at least $684 per week, or about $35,500 per year. And the way the DOL came up with those numbers is the same method it used in 2004. So it went back to that lowest wage census region, which again was the South, and then the national retail industry data, looked at the salaried workers, what their average pay was, and set the bar at the 20th percentile. And of course, since about 15 years had passed since 2004, there was an increase in the economy and in average wages and cost of living. And so the new 20th percentile amount increased from $455 per week to $684 per week. And there were some other changes that were discussed at that time that went into effect and are still on the books now. The DOL had previously tried to do automatic increases in 2016, which would have prevented a lot of this continuous rulemaking back and forth and would have set automatic threshold increases. The DOL did not try and do that in 2019. Essentially, they just upped that salary limit level to where the 20th percentile was now that 15 years had passed since 2004. And so that brings us to this year, and specifically about 2 months ago, on April 23rd, 2024, actually less than 2 months at this point, we received a new final rule from the Department of Labor. And so this slide has the updated figures. This is what the news hook is. This is why we're speaking with you all today, what the changes are and why our firm and the Department of Labor, and I'm sure plenty of other organizations, are doing as much outreach as possible to employers to know that they're aware of this information and the changes that are going into effect. So back in 1938, the early 20th century, the Department of Labor had set salary limits, and we've seen that gone up over time, especially in the last 20 years or so. There's been a lot of increases, and now we're at the most recent phase of that, where the salary limit that started at $455 in 2004 is now up to $844 per week will be the new minimum threshold. And that initial change goes into effect on July 1st of 2024. So just about 11 days from now, 1 week from Monday, that new change will go into effect. So if you have exempt employees who are exempt as executives, administrators, employees, or certain professionals, they need to be paid a salary basis and at a salary amount of at least $844 per week, or this $43,888 annual figure beginning July 1st. And DOL, I think, based on the experiences it had in 2016 and 2019, has gotten a little more creative and probably smarter too about the change. And they're not just increasing the threshold to that 20th percentile, they're trying to go a bit beyond that as well. And I'll talk about the rationale, but this is a two-step process. Before, every time one of these changes had been announced, It was a one-step change. It was a single increase that would go into effect. The DOL this year has announced a two-step increase. So we have that initial increase on July 1st of this year. That gets us up to the $844 per week amount. And then beginning on January 1st of next year, so just at the end of this year when the calendar turns over, there's going to be another increase to $1,128 per week, or a salary of about $58,600. So that's what the news has been about. If you've been hearing about that, this is the changes that are being made, and the reason why a lot of folks are starting to reconsider these things and try and figure out, what do we need to do? Does this apply to us? How do we need to implement that in our workplaces? And we've got more information about that. But if you're hearing about news stories regarding this, you're probably also hearing about potential litigation challenges. And I'll talk about that in just a few slides here. So in addition to the two-step process that will carry out in the next 6 months, DOL has also announced a plan to do automatic increases every 3 years. This is the same proposal that was made in 2016 and ultimately didn't get implemented, but DOL is trying it again here. And it would be 3 years from the first change. So July 1st, 2027, we would see additional increases, and every 3 years after that. And it would be keyed off of the January 1st, 2025 salary level changes. And you can see it on the bottom bullet point here on this slide, but I just can't say this enough. What we're talking about and the changes that are being made only apply to the salary level threshold. It has to be paid to an employee if you want to consider them exempt, not have to worry about timekeeping, using time clocks to punch in, punch out, pay overtime. If you want to pay someone exempt, they need to be paid on a salary basis, and it has to meet with the applicable threshold depending on when the time is. But the duties test, that salary requirement, that doesn't change. It's just the amount of salary that these employees are receiving. So we reviewed the 2004, the 2004, the 2016, and 2019 changes because they really foreshadow and set the stage for what the challenges are going to be. And part of that comes down to how the Department of Labor is setting these thresholds. So we have to look at these one at a time. In the July 1st, 2024 change that's going into place is one that really closely aligns with what the DOL has done in 2004 and 2019. And those were the two successful increases from the last 20 years. Those were not successfully challenged. They were able to go into place. We've been operating off the 2019 rules for about 5 years now. So this initial step is in line with those previous actions. It's really the January changes and the automatic increases after that, where the DOL has taken a step further and gone a little bit above what's been approved before in the past. And I saw that a question came in about a copy of the presentation. Just a reminder that we are looking into that and need to get final approval from my firm. But if that approval is granted, as soon as we've got that, we will be sharing the slides as well. So the January 1st, 2025 increase is going beyond the 20th percentile figure that the DOL has successfully relied on before. They're bumping that up even further to the 35th percentile, which again is why we're seeing a greater jump in salary in January of 2025 than even what we're seeing in July, a week from this Monday. And so that's a little bit below what the Department of Labor did in 2016 that got shut down. In 2016, the department used a 40th percentile figure. So they're going in a little bit below that, but it's expected that a lot of the challenges are going to look very similar to what they did in 2016. The way the Department of Labor has gone about addressing that is that there has been a two-part change to the process. And in the rule, it's included what's called a severability clause, which basically says that if a court looks at the rule and decides any part of it's invalid, it can't strike down the entire rule unless there's invalidity to the whole thing. So it has to take a more piecemeal approach. So in theory, a court could look at the rule and say, okay, the July 1st change is fine. That aligns closely with what the department has done before in 2004 and 2019. But this January change and the automatic increases, we've got concerns about that. A court could split those issues based on the severability clause, allow one to go forward while the other one gets held back. And I think that's just another example of kind of the ingenuity that the Department of Labor is displaying with these changes and trying to get its goals accomplished with these increases. And so the Department of Labor is not shying away from its rationales for these increases. It's doing a lot of promotion of the materials and the policies behind it. We've essentially seen two messages come out. One is the same thing we've said before, that the department needs to find a threshold that allows employers, employees, and the department itself to basically assume that there's a certain level of obviously exempt employees, and to use that threshold as the barometer for that analysis. But the DOL is also being very explicit in saying it wants to produce this rule in order to give workers more pay or more valuable time back with their family. Essentially, either if you're going to be paid a salary and expected to work more than 48 hours a week, that's, if you meet the exemption, that's fine, but you're going to get a higher salary as a result of that. Conversely, if you're not exempt and you're going to be paid overtime or limited in the hours that you can work, at least you have that time to go be with your family instead of working extra hours. I saw a few questions come in, so I'm just going to take those real quick before we move on further. One question is, do state salaries supersede federal? And I'll discuss that a little further in a moment when we're talking about coverage. But the short answer is yes, they can. The federal salary thresholds that we're talking about here today is the baseline, the minimum amount that those salary thresholds have to be. States are free to use higher thresholds if they want to. And if you are lucky enough to be in one of those states, then you have to comply with whatever law is most beneficial to the employee. I've got a slide in a few moments about which states have those, so you can know that. And if you're in one of those states, or if you have employees working in those states, you're going to be expected to comply with the higher level. Another question is, how does the salary threshold apply to a part-time employee, specifically a part-time teacher? That is a great question. The salary threshold is it's broken down into, we have the kind of annual figures and the weekly figures. And so it can be prorated based on how much time that employee is actually working per year. So if you have a teacher who traditionally has the summer off and they aren't paid 12 months out of the year, they're just paid for that work that's being performed while school is in session, they would need to be making the prorated equivalent of the salary threshold for however many months or weeks out of the year they're working. HCE is a term that's come up on a few slides. I'm not touching on it as much as we do with other employers because I'm guessing it's not as common for nonprofit organizations, but it's a good thing to be aware of. The HCE is the highly compensated employee test. Sometimes people mistakenly think of it as an additional exemption. It's just really actually a higher threshold like the salary level test that says, if you're making even above this additional threshold, which is now going to be in the $130,000, $140,000 range, if an employee is paid that much, we're actually going to decrease the intensity of the duties test as well. So you still have to pass the same requirements as the executive, administrative, or professional test. But if you're paying that employee so high, and it's a six-figure amount, so it's not always as common, that is getting increased as well as part of these changes. And if you clear that, it's a little bit lower bar as far as the duties go. So it's not its own exemption itself. It's just another way and way that we get to the analysis. I'm going to real quick just wrap up the anticipated challenges, and then we're getting a lot more questions in. Thank you for that. I will continue to go through those in just one moment here. So I just want to close the loop on the challenges, and then we'll get into coverage issues. So the reason why all that, the rationale and the decision-making process behind the DOL matters is because that's what's going to be litigated. The dollar amount is relatively straightforward. How the DOL got there is where it gets more complicated, and what we've seen in the past result in either these rules getting overturned or put on ice until there's further discussion, or they are successful and they get to go forward like we saw in 2019. So there have already been 3 lawsuits commenced challenging the new 2024 rule. They all happen to be in Texas federal district courts. There's 2 in the Eastern District, which is where we saw the 2016 rule overturned, and then another case in the Northern District of Texas. They've been brought, one by the state attorney general, another by a Chamber of Commerce organization, and another by just an employer. And there may have been additional ones since I last did my check on that, but rest assured, there are plenty of employers that disagree with the DOL changes and are in court fighting to have them either put on hold or overturned altogether. And the substance of those changes are similar to what we saw in 2016. Basically, by setting the salary threshold so high, the Department of Labor is overriding the duties test, making it almost irrelevant what folks are doing because they have to be paid so much. And that's really not the intent of what Congress wanted when it passed the FLSA almost 85 years ago. At least that's the argument that's being made. It'll be up to the courts to decide, and it's really a guessing game at this time as to how the courts are going to respond to those challenges and what outcomes we might have. It shouldn't be lost on anyone that in 2016, the challenge was successful and an injunction was put into place 1 week before the rule was supposed to go into effect. So we're technically outside of, there's more than a week to go before the July rule goes into effect. But I think when you look at the rationale and see that the DOL, at least for that first step of the change this year, is paralleling what it did in 2004 and 2019. And just the small window of time we have before that rule is set to go into effect. I don't think anyone can bank on the fact that there is a challenge pending and that rule might get overturned. The more prudent approach is to get your ducks in a row, be ready for those changes on July 1st, and then look ahead to January and the automatic increases after that. We've got more time. That's a greater increase by the department. The rationale for that's a little different. We'll just have to wait and see how these litigation challenges go. But for now, the best practice is probably to assume they're going to go forward and then wait and see. So I'm going to jump to FLSA coverage questions in a moment, but I'm going to try and catch up on a few of the questions that have been coming in. Let's see. Whether travel time counts as overtime is probably beyond the scope of our presentation today. That's a different can of worms that we can go into. Generally speaking, if it's travel time for work and someone's doing work during that travel, or they're traveling exclusively for work purposes, that can be, but there are a lot of exceptions to that as well. Another question is whether the overtime rate applies to any hours in excess of 40 hours per week. That's right. That is the federal standard, is that if someone's working more than 40 hours per week, they have to be paid an overtime rate of 1.5 times their regular hourly rate. So that is the overtime requirement. That can be different from state to state. Minnesota has a 48-hour threshold for what it's worth. But again, like with the salary limit test, we have to apply the rule that's the most beneficial to the employee. So even in Minnesota, where you have overtime, state overtime starting at 48 hours per week, employers that are covered by the FLSA are still expected to pay overtime starting at 40 hours. Municipalities with higher wages, such as San Francisco and Los Angeles, there's another question about that. Same as the states. If you're in a municipality that provides greater benefits to employees than the FLSA, that's each city's prerogative. And if you're either are an organization based there or you have employees working there, you need to be complying with whatever the most beneficial law is for the employees. And I see one question about moving employees to salary non-exempt. That is generally appropriate, and I'll talk in greater detail about that towards the end of the presentation. And so let's see, I'm seeing a lot of state-specific questions. I think the same standards apply. If the states or your cities that you happen to be in have greater standards, you're going to be complying with those. So I'm going to move into the coverage because I want to make sure we cover this for all the nonprofit employers out there. And it's a tricky issue that touches on some of these questions as well. So as I've been mentioning, the FLSA is the baseline requirement for minimum wage, overtime, and these exemptions. State laws and municipalities can have higher regulations that require greater benefits to employees. Your job is to apply the law that is most beneficial to the employee. This is a slide I was mentioning before that has the states with a different minimum salary than the FLSA. If you're working in one of these states and the salary threshold is higher than what the FLSA requires or what it's going to be changing to in July and January, then you might already be in compliance. And that's, one of the silver linings of being in some of these more progressive states that have been increasing its state overtime exemption limits already. You might already be in compliance and don't have to worry about the FLSA increases, but it's always very important to check your state laws too to determine what's applicable. So how to know if the FLSA applies is a fascinating question that lawyers like myself could spend days and days talking about. So I'm going to do a quick overview focused on nonprofit organizations in particular. And obviously, if you have questions, feel free to share them as well. I'll give you a caveat at the beginning. I can't give you advice on this presentation just in general. And for this particular issue, it is a very nuanced discussion that depends on the specific circumstances of each organization. And as we'll talk about, each employee that's at issue as well. So it's really an analysis that needs to be done with your own legal counsel based on your own circumstances. But this is a general overview based on the DOL regulations and the information that's out there. And hopefully it will give you an area of kind of what information to be looking for. So generally there's two ways to know if the FLSA applies. One is called the enterprise coverage test, and the other is the individual coverage. I'll talk about both and more specifically here in a moment, but enterprise is generally the employer test and individual applies to the employee at issue. So the FLSA applies to employees who work for certain enterprises, and it defines an enterprise in two ways. The simplest is the bottom bullet point here. The FLSA just says categorically, if you're a hospital, if you are a business providing medical or nursing care for residents, schools, preschools, government agencies, those types of entities are categorically considered an enterprise and therefore covered by the FLSA. For nonprofits, in my experience, hospitals is probably the most common application of that rule. Regardless of whether you're a nonprofit or not, if your organization is providing hospital services, that is going to be covered by the FLSA, and you're subject to everything we've been talking about here. The other way an entity can qualify as an FLSA covered enterprise is based on the amount of sales or business that it does and whether it exceeds a $500,000 annual threshold. And I'll talk about it in a bit. This is complicated for nonprofit organizations that often have mixes of commercial and charitable purposes, but that is generally the threshold. Obviously, if you're not in the nonprofit world, that's a pretty low bar to cover. And it's very rare for for-profit entities to not be exceeding that amount, especially when you've got enough employees that you're going to be worried about exemption status to begin with. So obviously that begs the question, can a nonprofit be an enterprise? And the biggest, other than the salary limit increases that we talked about a moment ago and highlighted that are going into effect on July 1st and January 1st, the biggest takeaway that I can offer for you now is that the DOL promotes this as saying many nonprofit organizations are covered by the FLSA. And I think that is the most prudent starting point for any of this analysis. There is no default rule that says if you are a nonprofit, you're not covered by the FLSA. The analysis is more complicated on that. And if you're starting to think, or you hear other people in your organization say, hey, none of that matters because we're a nonprofit, the FLSA doesn't cover us, that should be a red flag for you, because it's not that simple, and that's not how the determination is made, either by the department or the courts if we get into a litigation situation. That's not to say that every nonprofit is an enterprise. It just means we have to go through the more detailed analysis. And so again, if you're a certain type of entity, if you're a hospital or residential care facility, that's a simpler analysis. You're going to typically be covered as an enterprise. But if not, we have to talk about what kind of money that's coming into your organization, where it's coming from, and whether it exceeds that $500,000 threshold. So the FLSA and the Department of Labor has identified charitable contributions are not considered. They don't count towards the $500,000 threshold. So that's donation, membership fees, dues, those sorts of things that are paid in furtherance of the organization's charitable activities. That doesn't count. But if you have a commercial arm of your organization that is doing business type work that's arguably competitive with other businesses, that can be considered activities performed for a business purpose and then count towards the $500,000 threshold. The examples that the Department of Labor gives are churches with book publications that are producing their own materials, publishing it, and selling that out to the community. That's arguably competitive activity compared to for-profit book publishers. So that information, that dollar amount, those are being considered as business purposes and contributing to the enterprise threshold. Gift shops are another example, and I'll talk a little bit more about this veterinary services example in a moment, because I think it's a helpful illustration of these issues. So that we've been talking about the enterprise test. That's only one of the two ways you can get coverage under the FLSA. In order to conclude that you are not covered by the FLSA, you have to not qualify under the enterprise test and also the individual test as well that we're going to talk about here now. So it's both, and those two things have to, neither of them can apply to you. And then you can start talking about, okay, we're not covered by the FLSA. But if you're either covered under the enterprise coverage test, or if your employees are covered under the individual coverage test, then the FLSA is going to apply, and you need to either be paying minimum wage and overtime or have an exemption that can apply to the particular employees at issue. So if you go through the enterprise analysis and say, we're a nonprofit, all our activities are charitable, we don't have a business purpose, we don't meet that $500,000 threshold, we aren't a hospital or other defined activity, or excuse me, organization that qualifies an enterprise, we fail the enterprise coverage test, you're not done there. You still have to go through each employee that you think might be exempt and determine whether they are covered under the FLSA as well. And the test here is, with modern technology, it is hard to imagine many employees that don't meet the individual coverage test. What we're thinking about here is, does that individual's work activities involve interstate commerce? That's a kind of federal term of art for lawyers, but essentially what we're talking about is that person crossing state lines as part of their work? That can be a very literal interpretation of someone physically driving across state lines as part of their work for your organization. It could be, sending out packages through the mail across state lines. but also with remote work, with the impact of the internet, computers, telephone calls, all those things are traveling through interstate commerce across state lines. So if you have an employee who's regularly making telephone calls to people located in other states, that person is engaged in interstate commerce and likely qualifies under the individual coverage test for the FLSA and is protected by all the federal regulations we've been talking about here. So again, just to put a point on that, even if you don't think your enterprise is covered as an organization, you still might have individual employees who are covered under this separate test. So this is one of the examples that the Department of Labor gives that I thought was helpful to illustrate these issues. It imagines a nonprofit animal shelter. And I think that's worth pausing at right there, because we have a nonprofit organization. That distinction by itself doesn't determine whether there's FLSA coverage or not. You still have to go through both the enterprise and the individual coverage analysis. So this nonprofit animal shelter is providing veterinary care, adoption services, and shelter for homeless animals. The DOL considers that to be charitable activities. So money made based toward, like if they get donations to carry out those charitable activities, that is not going to be contributing toward the $500,000 threshold for the enterprise coverage test. But this particular shelter also provides veterinary care for a fee to customers. DOL qualifies to this as a commercial activity. The logic being that's technically in competition with other veterinary organizations and service providers in the community. So the DOL says if the revenue generated from the organization's commercial activities is at least $500,000 in a year, the employees who are engaged in those commercial activities are protected by the FLSA on an enterprise basis. Employees of the organization's charitable activities are not covered on an enterprise basis, since those activities do not have a business purpose. So I like this example because I think it shows the nuance and the level of detail you have to get with these coverage questions. Again, it's not enough just to say this is a nonprofit, and so we know the answer. We don't. We have to dive in further. You have to determine what extent of the activities that the nonprofit does are considered charitable, what extent might be they considered commercial. Are we exceeding that $500,000 threshold based on the commercial activities? And then even then, which employees are doing which kind of work is all part of the analysis as well. And that's just for the enterprise test. Even if you have an employee who's doing the charitable activity work for this veterinary or for this animal shelter, if they're crossing state lines to go provide those free services, that's potentially getting individual coverage for those individuals as well. And again, since we're talking about nonprofits, another issue that often comes up is volunteers. Hopefully you all are aware of this already, but a genuine volunteer is not an employee. So they are not covered by the FLSA on that basis. We don't have to worry about the enterprise or the individual coverage test. That is only looking at employer-employee relationships. So if you have a bona fide volunteer, someone who's providing their services freely out of the goodness of their heart without any expectation of being compensated or replacing the paid work of other individuals in your organization, those services can be provided without regard to the FLSA because that person is a volunteer and not an employee. And obviously, since you all are nonprofit organizations, you already have that public service or religious or humanitarian objective. That makes that analysis a lot easier. It's harder to say someone's volunteering for a big for-profit corporation. So I at least wanted to touch on that. And another common exception for nonprofits, especially religious ones, is what's known as the ministerial exception. If you have employees who are working as pastors, deacons, whatever their job title might be, if they're in that role of conveying your religious organization's message and carrying out its mission, they are not subject to the federal FLSA. And that's based on a First Amendment First Amendment interpretation that courts have recognized over the years. It doesn't come from the FLSA itself or from the Department of Labor, but courts have said, the separation of church and state also applies to the government telling religious organizations how or when to pay their employees too. There has to be separation there. So if you fit within this ministerial exception, that is a potential way also to avoid the effects of the FLSA. So we've got about 10 minutes left. I've got a few slides on how we go about these exemption audits. And if you're thinking about changing or reclassifying employees, what our recommendations are for handling those situations. And then we still have some questions that I will start digging into as well. So if you've got any more, feel free to throw those in and I will get into as many as I can before our hour is up here. So once you've taken in all the information today, and there's no shortage of it, I realize, and you've made a determination that we're covered, we have concerns about the FLSA, we need to reevaluate our stuff. How do we go about doing that? Again, the starting point is that the only thing changing is the salary threshold for exempt employees. So if you're already paying folks on an hourly basis, or you're paying them a salaried non-exempt, and they have a potential to earn overtime anyway, you're not worrying about them, at least for this part of the analysis. The focus is on exempt employees who are paid a salary of less than $43,888 per year. If they're making more than that, you're already in compliance with the law that's going into effect a week from Monday. It's just the folks that are below that threshold that we need to look at. And really, this should be an opportunity to take a holistic look at that person and say, why do we consider them exempt in the first place? How confident are we in that exemption? Do we really need them to be exempt? And how much are they actually working? That's an important part of this too. Sometimes we focus so much on the exempt, non-exempt distinction, but we don't see the actual practical results of it. If you've got an exempt employee who only works, 20 to 35 hours a week, and they aren't going over that 40-hour threshold for overtime, then maybe it doesn't matter. Maybe we're fine paying them, and as a non-exempt employee, they can still be paid a salary, and we'll just be mindful of what their overtime requirements may be. Once you've gathered all that information, the first question is, are we going to reclassify that person, which means moving them from exempt position or exempt status to non-exempt status, or if we're going to keep them as exempt, are we going to raise their salary to meet the new threshold? So if you're wanting to reclassify an employee as exempt or non-exempt, you need to determine how they're going to be paid as a non-exempt employee, and then what policies might you need to do that. One of the questions that had come in is, can we pay, let me make sure I get it so I have the language correctly. It might have been, oops, scrolling the wrong thing, sorry about that. If you're going to pay someone or reclassify someone as non-exempt, the most straightforward thing is to pay them at an hourly rate, and then if they work overtime, they get 1.5 times that. There is also a legitimate category of employees that are non-exempt but are paid on a salary basis. You're still going to want to know, it makes it harder to determine what the hourly rate is, what their effective regular rate is, and if they do work at overtime, what they're covered. For that, it's a complicated analysis that's a little bit beyond the scope of our discussion today, but that's one option that's out there. And if you are moving someone from exempt to non-exempt, which means that they're going to be entitled to recover overtime if they're working more than 40 hours per week, you might consider putting in policies in place. We always have to pay employees for the hours that they actually work within the scope of their job and that we had reason to know about. But you might have a policy that says you can't work overtime unless you get prior approval. It's a common tool for employers. And that way, if someone keeps going into overtime and it's getting really expensive to pay them, you still have to pay them for that time, but you can then go back and say, hey, we've got this policy that says you need to get prior approval. You haven't been doing that, so we're going to discipline based on that violation and potentially terminate someone if they continue to violate that policy. They're getting what they're paid for their wages and what they're entitled to under the law, but they also have to comply with these policies as well. So And then if you're going to leave someone as exempt, if you're very confident about the exemption, it's important to keep them there and not have to worry about overtime. There needs to be an increase in the rate of the amount of the salary. And really, it's just a question of when are we going to do that? How are we going to make that announcement? Are we going to wait and see the results of these challenges, or do we just want to get in compliance as soon as possible and do that? And then, of course, that's the analysis for July 1st. Basically, you have to wash and rinse and repeat these steps for the January 1st changes. You're starting to look at the higher threshold, the $58,000 salary threshold. If you got HCE employees, those numbers are going up as well. But our work isn't done after July 1st. It continues for the next round of increases in January, then obviously for 3 years after that as well. So there's always questions about communications and training. Again, unfortunately, beyond what we have time for today, but it's important if you're moving someone that's used to just showing up to work and getting paid their salary, if they're going to start clocking in, getting paid hourly, working in overtime, potentially having that, it's important to train those folks on what our expectations are for all those things. And not just the affected employees, their supervisors and managers as well need to know what those changes are. And then just a final reminder that we're only changing the salary test. So the duties test does not change whether someone's exempt or not based on how many employees they supervise and the other duties requirements of the executive exemption. That's not changing. It's just how much they're being paid for the salary. So I will take the rest of our time here to try and answer questions. If you've got any, feel free to add them in the chat. We've got quite a few. I will do as many as I can. Let's see. Someone asked, can a non-exempt employee work remotely? I have an exempt employee who works remotely, but with the change, she will now be non-exempt. The exempt status only matters under the FLSA to overtime and minimum wage. So where that person works, how they go about working, even if they're non-exempt, they can certainly still be remote. And that's a relationship or an arrangement that we're seeing increasingly after COVID as well. The salary levels do not apply to teachers, 17G. That is correct. And that's a good point. I had kind of gone down a track of teacher questions. There are certain professional exemptions that are not being affected by these changes. Primarily, it's for doctors and lawyers, which I don't always associate with nonprofits. It's not always the most common arrangement. Teachers is another one that salary threshold is not changing for teachers. So I think in response to a question earlier that used teachers as an example of a part-time employee, we kind of went down that rabbit hole, but that is a very good call out that the salary threshold increases do not apply to all professional employees, the main categories being, doctors, lawyers, and teachers. If an employee meets the duties test, can they be switched to hourly and paid overtime, or do we need to adjust their job description duties? No, they do not need to have their job duties switched. That is just part of the test to determine if an exemption applies. Even if an employee meets the exemption, you always have the option to pay them an hourly rate, pay them overtime at 1.5 times that rate for hours worked over 40 in a work week. This is just for employers that look at their employees and for whatever reason, for business purposes, financial reasons, they don't want to have to worry about clocking in and out and paying those overtime rates. You have the option to pay on a salary basis without consideration of overtime if the exemptions are met. But even if the exemption is met, you always have the opportunity to effectively give that person the benefit of the FLSA, pay them hourly, have them record their hours, pay them at the overtime rate as well. Someone had asked, was the injunction against the 2016 increase nationwide, or was it like the COVID vaccine injunctions that applied only in the states that were part of the litigation? It was a nationwide injunction. There's been questions about whether district courts in particular areas, this one was in the Eastern District of Texas, have the legal authority to do nationwide injunctions. But in 2016, that was what was implemented and gone into effect. I don't know how the Department of Labor is defending against the current challenges, but that might be something that they're looking at as well, is can this court in Texas tell the rest of the country what the DOL regulations are as they apply to them? Arguably outside of that court's jurisdiction. But yes, in 2016, it was a nationwide injunction. Someone else had brought up 17G, the salary basis test exemptions for professional. That's the same thing I was discussing before. I see a few comments on that. I apologize that I glazed over that before. Just like, again, a reminder that the salary level the salary level increases that we're talking about apply to all executive and administrative exemptions, and they apply to most professional exemptions, but not all of them. There are some subcategories of professionally exempt employees that aren't going to be affected by this increase here. I appreciate folks calling that out. Someone had asked if our salary exempt employees will now make under this new threshold, can we move those employees to an hourly employee? I think maybe a word was missed in that question, but yes, generally, if you've got folks that are currently salaried and exempt, you can, I think of it as a downshift. It's not necessarily up or down, but you can reclassify them as hourly employees. I see we're at past 101. And so I'm going to wrap up and thank you all for your time. Mac, if you want to, I'd be more than happy to try and follow up with folks that have questions. I know there's going to be a survey that's sent around as well. If questions come in that way, I'd be more than happy to reach out. Otherwise, you all have my contact information on the event page as well. More than happy to have these discussions and try and help you however we can.
Perfect. Thank you so much for your